Hi guys. So today's webinar is on a very important topic, which is funding due diligence. So due diligence is a process which is usually being discussed in every industry, may it be startups, may it be small medium enterprises, small medium business, big businesses, everywhere. So due diligence is a very important one, and we are going to discuss today on due diligence with special focus on funding due diligence. So in this webinar, we will be mainly discussing on what is due diligence, why due diligence is necessary, the key areas of due diligence, and as it is funding due diligence, so we would be discussing on how to ensure that you are successful in fundraising. So coming to the first slide, what is due diligence? The first thing. So due diligence is a process of examination and investigation that a business or a person usually undertakes before entering into an agreement or a contract, mostly common in mergers and acquisitions. So in any case, when there is a merger, when there is an acquisition, or an investor comes in to invest in the company, they usually go with the process of due diligence. So what do they do in this due diligence process? They usually examine the papers, the accounts, and there are various other things which they examine and investigate so that they can take a prudent decision about how should they move forward. It might be a signing of an agreement, before signing an agreement or a contract. It might be to enter into a joint venture. It might be for a merger. It might be for a takeover or an acquisition, whatever the case may be. But every business or any individual, before entering into such things, they usually wish to go ahead with a due diligence process. Coming to what is the necessity of due diligence? Why is due diligence important? And today we are going to discuss on these things first, and how is it going to impact the business, how the due diligence process is going to impact the business. So the first point of the necessity of a due diligence is, due diligence helps in ascertaining the viability of a proposed project, may it be a contract or merger or takeover, whatever it is. So when a person or a business go ahead with the due diligence process, it helps them to take the decision. It helps them to ascertain whether they are going to take the right decision of making the investment or getting into an agreement or takeover. So it helps them in ascertaining. It helps them in making the decision, in taking any decision. Due diligence, so as it is from funding point of view, so due diligence protect investors from sudden and undue losses. So consider a situation when an investor wishes to invest in a particular company. They come ahead and show their interest to invest in the company, and after some discussion with the founders and the promoters, they invest in the company. After a year or two, it might happen that the company had been in operations for 2, 3, 4 years, and there were some irregularities in the company. So after 2, 3 years, it might happen that suddenly a regulatory body might have sent a notice saying that there had been some issues, there had been some non-compliance, and as a result, the company has to pay a penalty, a certain penalty. And in that case, the investors also suffer, apart from the founders and the promoters. Now, why do the investors suffer? Because the investor has put in the money for getting some kind of return from the company. So he has got that return in his mind. So if that is not protected, so when a regulatory body penalizes a company, it also affects the investors as well. So due diligence protects these investors from sudden and undue losses. So you decide beforehand, before you invest in the company, you can decide whether this company is the right thing to invest, whether the company is the right one where you wish to, where the investors really wish to invest. The third one is due diligence shield investors from unwanted surprises. So again the same thing, like it might happen that you might have known a part of the company. So the company might be working for last 5 years, and you have known the company for last 1 year, and after a year you have decided to invest in the company. Now it might happen that for the last 1 year the company has been performing very well and all the compliances are in place, but you never know what had happened 3 years past. So when you go ahead with the due diligence, you scrutinize all the documents from the inception till the date you invest in the company, till the date the investors invest in the company. So it helps them to shield themselves from unwanted surprises. So in that case, what would happen is the investors would get surprised to see that, I have known the company for last 1 year and the company had been in compliance for last 1 year so well, but I didn't know that the company had not filed a return, the company had not submitted the financial statements in a particular year. Now these kind of surprises might again give the investors or land up the investors in a big loss. Due diligence, this is another very important point. Due diligence helps both the investors and the founders to arrive at a right valuation for investment. So when there is an investment proposal from the investors, the founders and the investors, they both sit and decide together what should be the right valuation. So this due diligence, this helps both the investors and the founders to negotiate the right valuation. How do they do this? So I would be talking this point from both investors and founders perspective. So first I would like to speak from the founders perspective. So what happens? You as a founder, you might start a company. The company has been doing very well. You have, all the compliances are in place. Everything is right, intact, and you have done the company very well. And now the company is growing, and you have decided to raise an investment. You go to the investors, and you were successfully managed to impress the investors, and they have agreed to put in the money. Now the next stage is deciding on the valuation, what value they are going to invest. This point of time, the founders can say that, look, these are my papers. The investors will definitely go for a due diligence check, and at that point of time, the founders can put their view that, see, I have these papers, everything has been done on time, all the compliances are in place, and everything has been done rightly and in compliance with all the regulatory issues, and is in compliance with all the acts. By saying so, the founders, they put up their view across to the investors, saying that the company is perfectly okay and you would not bear any losses in the long run. Does the company deserve this kind of valuation, this much of valuation? From the investor's point of view, it might happen that the company and the founders, they have not complied with some part of things. And at that point of time, the investors, to protect their right, they can say that I am ready to put in the money into the company, but I would not like to put in the money at this much of valuation, and I would give this valuation, so a little lower valuation if the compliances are not in place. If the compliances if all the compliances are in place, then the investors and founders can negotiate and decide the right price, so that both the parties are happy at a valuation they arrive at. But this due diligence process helps them to arrive at a right valuation and to negotiate well with each other. So due diligence, the other point is due diligence helps in creating a win-win situation for both founders and investors. So the last point, as I said, so both of them have their own perspective. They can look from a different point of view. So founders, they can say that I deserve this, the company deserves this valuation. because the company has done so well and the company's compliances are in place. And the investors can also see that yes, if they invest in a company with all the laws and the company is a growing company, their investment is going to fetch them the return. So due diligence. So when the due diligence process is done properly, both by the founders and the investors as well, this helps them to create a win-win situation. So they arrive at a situation when they both the parties can get the maximum benefit. Coming to the areas of due diligence, the main idea behind this was to give our viewers the idea to understand what are the points they should focus on. May it be investors, may it be founders. So there are few areas where the due diligence process should be conducted so that they can take the right decision. The first and the foremost thing which almost every investor, every acquiring company undertake is the financial due diligence. So what is financial due diligence? What are covered in this financial due diligence? So the details in financial due diligence would include company's financial statements. So the acquirer or the investor might ask for these details, or they usually ask for these details. Company's financial statements. These include quarterly financial statements, half yearly, annual, everything. The loans taken by the company. So the company might have taken loans from any party, from another company, from a public financial institutions, from an NBFC, from a bank, whatever it is. The investor might want to know what are the loans taken by the company and from which person or which bodies, what are the source of taking the loans. The third one is a percentage of bad debts, because this is going to create a big issue in the future. This might create a huge issue in the future. Percentage of bad debts. So if there is a huge number of bad debts, the percentage of bad debts is huge in the books. So this might affect the working of the company in a long run, and this might also affect the investors as well. So they wish to know the percentage of bad debts. The other one is the life cycle of the accounts receivable. So you sell a service or you sell a product, any company, it is a common practice. The company sells the product, the company sells a service. And at a lot of times it happens that you need to, the invoices are pending. So, and it takes some time for the invoice, for the accounts to get received in the bank accounts of the company. So the investors need to know what is the life cycle of that. So if you raise an invoice today, how much time does it take for the amount to be received in the bank account of the company? So this is a very important part. And the last one is the working capital requirements. The most important thing, the working capital requirements. A company needs to have a well working capital. So working capital requirement is something like a company should have working capital requirement to service the company in the ongoing process. So company will have to pay the salary, company will have to repay the loans, the company will have to pay certain invoices for getting some services or whatever it is. There are certain elements where the company has to keep paying on a day-to-day basis. So the investors wish to know what are the requirements, what are the working capital requirements, what are the requirements of the capital so that the company. So these are very important things which the investors ask in financial due diligence. Apart from that, the investors also ask for cash flow statement. They wish to know whether the company has a positive cash flow. Along with the financial statement, when they ask for the company's financial statements, they won't really ask only for the balance sheet and PL. They will also ask for the notes to accounts as well. So which gives all the details of the financial statements. So this is about the financial due diligence. The second one is any contracts or arrangements. So what is really covered in contracts or arrangements? So shareholders or promoters or employment agreement, So this is very important. The company might have started 3 years back, and there might have been some initial investments from friends or family. There might have been some change in the promoters who have come in, and they might have signed a particular agreement amongst themselves. So the investor should go through a thorough check on these kind of agreements, the shareholders, promoters, and employment agreement. Another agreement is the indemnification agreement. So indemnification agreement is an agreement which the company and the promoters or the founders sign with a third party, wherein they say that if there is some kind of losses made, then the company would be liable for the company would indemnify that third party. So indemnification agreement, why is it important from the investor's point of view? That say the investors have put in a certain amount of money, and then it has been found out that the company has done a mistake, and the company has to pay a sum of 5 lakh of rupees as an indemnification. So in that case, the investors might have put in 50 lakhs, out of which the 5 lakhs will go for indemnification. So the investors, it is very important for the investors to check if there is any indemnification being signed by the company. The third one is any JV or partnership agreement or any memorandum of understanding which has been signed by the company with any other entities. The other agreement can be service agreement. So service agreement would be you as a company, the company might be providing some kind of services to a third party, or might be receiving some kind of services from a third party. So it is again another important point that the investors can look into, that what are the service agreements, or if any service agreements have been signed by the company. Exclusivity agreement. So in this agreement, usually what happens, the company can get into an agreement and say that certain sort of things are not covered between the two parties who have signed the agreement. So these things are excluded. So what is excluded? It might happen that few things which might affect the business operations of the company might get excluded. And in that case, the investors who have really thought that they would put in the money and the company would work in certain things or certain areas, and these are not being, the company by virtue of signing the exclusivity agreement would not be able to execute those things. And in that case, it would be a big loss for the investors. So again, exclusivity agreement is a very important agreement that should be checked by the investors. The other one is a non-competitive agreement. So non-competitive agreement is like a company is working in a particular sector. They have got some. They are receiving some particular service from a different company, and they are working in the same sector. They might have signed a non-competitive agreement wherein they agree that the other party will not do this kind of things, and this party will not do this kind of things. Now again, this kind of agreements might affect the interest of the investors. So again, for investors, it is very important that they check if there are any non-competitive agreements being signed. Apart from that, the investors can also check various other things, like if there are any power of attorney being signed, if there are any customer or supplier contract being signed, any lease agreement or equity finance agreement. So there can be a number of agreements which the company may sign, but these are few important ones. The other one, this is again a very important one, and we have been seeing that there have been several litigations in intellectual property. So intellectual property has become a very important point from the investor's point of view, and we see that the founders have also started giving it importance as well. So registration of trademark, patents have become very important for both the companies, for every company, as well as the I'm sorry. So it has become very important for every company, and it has become very important from the investors as well to check whether the company has got what is the company, what are the company's rights from the intellectual property point of view. So what do they check? What are the checkpoints here? So first one is if the company has got any registered trademarks or patents, and if there are any pending applications on the same, they can check them. The second one is if there are any IP protected products or services which are being used by the company, and do they have any legal right to use them? Recently, there has been a case where a company which has been in operations for last 10-15 years, they have been using a particular brand name in the company, and the company had been doing very well, and suddenly a big company which had a trademark registered with the same brand had sued this company. Now this is a very practical experience I am talking about, which had happened very recently. Had sued this company, and the company was penalized with a huge sum. So had there been a legal right to use the IP protected brand, there had not been this issue with the company and the founder. Now, for an investor, this is very important that they check if the company is using any such brand which is already registered, which is already protected by IP, and if they are using it, do they have the legal right to use them? The third one can be dependency of the business on the name or brand. So there might be several names or brands, they might be using something. So the investors can check how much is the business dependent on that name or brand. It's not always necessary that a brand is always, that the particular name of the brand is always acting as a deciding force of the business. It might be something else. It might be the face of the founders. It might be the quality of the service. It might be, there can be a number of things, but they need to check how much is the business dependent on the brand. They can also check if there are any IP rights granted by the company to any other third party. So the company might have a IP registered under its name, and they might have given the legal right to use it to some other party. So the investors should check that as well. The last one can be indemnities companies obtain from the third party. So what are the indemnities? So it might happen that, both ways, whether you might have used IP protected right. So what are the indemnities? Or you have provided someone to use this, and if there are any indemnities that the company has provided to the third party. So you need to check. So the investors need to check this as well. So these are from the intellectual property due diligence point of view. The other one is, this is a very important part, and a lot of times this gets neglected, whether intentionally or unintentionally, which is called the litigation. And litigation, in the past 2-3 years, we have seen that the companies have been issued notices on certain grounds, on various grounds, and they have been facing litigation. So how do they check? What are the important points on where the investors can check on? So one is litigations filed by or against the company. So if there are any litigations which the company has filed, or the litigations which has been filed against the company, they can check them. If there are any litigations which has been settled by the company, so it might be so that a litigation had occurred somewhere 2-3 months or a year back, and now that has been settled. So they should check that as well. Any order passed against the company. So there might be some order which has been passed against the company, the proceedings are on, or if there are any stay orders, so they should check that as well. If there are any cases pending under arbitration, so usually between two parties where there is an agreement, it happens that the parties wish to solve the problem through arbitration. So if that be the case, then that might be the case. Then in that case, it is important for the investors to also check if there are any arbitration cases pending. The last one is government or quasi-judicial proceedings against the company. So if there are any government proceedings against the company might have not paid taxes for last 3 years, and the income tax department might have issued a notice to the company. So in that case, there might be some proceedings against the company, some penalty might be levied against the company. They should also check this. Apart from this, some other things which should also be checked by the investors, like the charter documents of the company. These are usually being asked during the due diligence process. Statutory register of the company. So talking from the founder's point of view, it is again very important that, and particularly in the startup and SME industry, we see that the statutory register is not being maintained properly by a company. They do have MOA, AOA because these are part of the incorporation documents. You start the company with these documents, but the statutory register is not maintained by a company properly. So the company might have received funding 2 times from friends and families or from other co-founders, and in that case there might be 10 to 12 shareholders. So everyone should have a folio number, everyone should have a particular distinctive number, certificate number. Now these things should get reflected in the statutory register, apart from various other things which gets reflected in the statutory register. But these things usually seem to be missing in a startups and SME companies. So it is very important from the founder's point of view that the company maintains the statutory register and it is being updated regularly. Details of security holders like convertible debentures, preference shares, etc. So these things the investors usually check again. Details of ESOP granted or vested, sweat equity promised or issued. So if such kind of things have been done in the company, the investors again do ask for these things. Or any other kind of agreement or document on capitalization of loan. So that a director has given a loan of 50 lakh rupees 3 years back, and he has signed an agreement with the company that after this much of years, this loan shall be converted into equity. So these kind of things might dilute the shareholding of the investors. So it is very important for the investors again as well to check if there is any agreement on capitalization of loan. So after discussing on all the areas, we now come to the last part where we discuss on how to ensure successful fundraise on due diligence. So the due diligence process gets completed. Now how do you ensure a successful fundraise? So the first thing, the documentations of the company should be in compliance with the law. So every document that you prepare starting from incorporation, they should be in compliance with the law. It doesn't make sense that you have been keeping all the documents, whatever you got, you have kept it in the record of the company. That doesn't only serve the purpose. You have to do it in compliance with the law. So if it is not in compliance with the law, it doesn't matter. I mean, even if you have maintained the documents, it doesn't matter. The book of accounts of a company are of prime importance and should be prepared with utmost sincerity. So when the book of accounts are prepared, so financial health of a company decides what the company really is, because this is something tangible and you can really, these are visible things. So you can see the figures and you can really understand what the company is doing and how the company is performing. And this has been done by, and how do we understand it? This is being understood by looking at the book of accounts. So if the book of accounts are not prepared properly, it cannot be really understood what the company is doing. So a company might have a revenue of 10 CR or 50 CR or 100 CR, but it doesn't matter if you do not maintain the book of accounts properly. And we have been seeing such kind of things for a long time now, wherein a lot of companies have started a company 3-4 years back. They have been doing really well, but the book of accounts have not been maintained properly. And as a result, there were no statutory audits being held, timely returns were not filed, the income tax returns were not filed. In case of GST, they have not taken GST registration, they have not filed a GST return. So n number of issues might crop up, and this might really impact the functioning of the company, and the company might fail in a near or long term. The other point is the operations of the company should be conducted keeping the investors in confidence. So this point is from the point of view that you have already, you are already in discussion with the investors, and the investors are conducting the due diligence. So during that process, you cannot stop the operations of the company and you need to carry on the business. So how do you really carry on? So whenever you take a major decision, it is important that you keep the investors in confidence and then take the decision and carry on with the operations of the company. Another important point is whenever you have different parties with whom you deal with, the founders should pay very important attention here that they should execute agreements and contracts so that there is no misunderstanding with different parties. So there might be several kind of services, several kind of things you might decide with different parties, where you would do certain kind of things, or where you would receive certain kind of things. So you should not do it verbally or orally. You should execute an agreement so that it becomes clear for the investor when they come to understand what you have been doing with that particular party, and what are the things, or what are the obligations of the other party, or what are the obligations of the founder, what are the obligations of the company, what are the rights of the company. This becomes clear when you execute an agreement with the parties, and this helps in avoiding misunderstanding. Again, a very important point the startup founders usually miss on this. You should always keep tracking the performance of the company and taking necessary steps. Just starting a company and running it is not enough. You need to keep tracking the performance. So you can set a deadline of maybe quarter or a half year or a monthly. The board can meet with the advisors and they can decide whether you can decide whether the company has been able to achieve the things, whether the company has done the right things during this period. If not, then you should take corrective steps to ensure that the things are not repeated again and you can perform in a better way. This is again on the same line, the reviewing the documents of the company at regular intervals and maintaining the records. So there so on the last point we discussed on you should sit on it and you should see if there is anything wrong. This one is about the reviewing of the documents. So when you sit on the things on how the company has been performing, you should also review the documents at the same time so that you can maintain the records. So linking it to the point where we talked on maintaining the statutory register, so there might be a case in onboarded, so you should update the register at that point of time. So when you sit after in a period of 1 month or 2 months or 3 months, whatever it is, you can update the records. So this helps. The very important point is, in Silicon Valley it is being said that investment is being raised from investors when you build a relationship with them. So it is very important that you build relationship with the investors. Apart from your company performing well, all the documents are in place, everything has been done perfectly, the company has a huge growth prospect, you should build a very good relationship with your investors to ensure that you raise funds successfully. Otherwise, a lot of times it had happened that after successful due diligence, the investment has failed or the investment has failed. In case of failed due diligence, there are hardly any chances that you would be able to raise funds. But in case of successful due diligence as well, the investments have failed. So it is very important that you build a good relationship with the investors. The other one is, how do you really ensure that everything is in place and you can carry on with the business of the company without any headache? So take help of an expert for company's compliance and allied matters. It's so in today's world we see outsourcing. So in everything, you might be working on a particular field, but you have outsourced something. And it is a very common thing because it doesn't make sense to work on something which is not your forte, or which is not where it is not worth you being putting the time. So always take help of an expert who is expert in certain things, who is expert in legal things, who is expert on tax, who is expert in accounts. So take help of an expert in complying with the law so that you are prepared beforehand when you go to raise funds. So this brings us to the end of this webinar. We have mostly covered all the points. In case you have any further query, or in case you wish to understand more on due diligence, or you wish to undertake due diligence, do mail us at info@taxmantra.com. Thank you.